Good afternoon, everyone. My name is Nancy Lopez. I'm a board member for DC Refers, and I am so happy to offer this program today, along with our co-sponsors, the Metropolitan Washington Employment Lawyers Association and the DC Bar Labor and Employment Lawyer community of the DC Bar. We are thrilled to have you all here. For those of you who are just joining, feel free to put your name and employer in the chat so we have a sense of who is here with us. We're going to start out today with just a quick introduction to DC Refers. It is an online directory of lawyers who are offer reduced fee services to people of modest means. And it's a network of affordable lawyers and mediators. The focus of DC Refers is to provide reduced fee services to people of modest means. And this shows you that the poverty guidelines between 200 and 400% of the federal poverty guidelines is what we consider modest means. They're people who earn too much to qualify for free legal services, but not enough usually to pay market rates for legal services. So although our focus is on serving modest means clients, DC Refers is also a trusted source of referrals for incomes of all clients of all income levels. And so if people are over that 400% of the federal poverty guidelines rate, the lawyer and the client can negotiate their usual rates for those services. Folks come to the DC Refers online directory from court resource centers, from legal services providers, from referrals, social media, community organizations. And we offer a wide variety of practice areas, including employment law. And last year, you can see the types of cases that were most commonly referred to DC Refers lawyers: family law, landlord entitlement law, but then employment law was our third most popular, most needed resource. The lawyers that participate in DC Refers right now are on your screen. Hopefully you see some familiar names, but I want to encourage any of you who have at least 2 years of legal experience and are interested in giving back by joining DC Refers to do so. We are right now in the middle of a fall fundraising match. We have a $5,000 match, and so any donation you make to DC Refers will be matched dollar for dollar, and that goes through the end of the year. We're one of the most frugal nonprofits. We do a lot by our fantastic board of directors who are all volunteer. And then I want to encourage you to check out DC Refers on social media as well. I will put the link to DC Refers in the chat in just a moment, so you can learn more. And if you're interested in applying to join our directory, you can find out more about that there as well. But to get to what we are really here today, to talk about AI issues for low-wage workers and their lawyers, I am so pleased to have Steve Pershing here as our moderator. He is of counsel to Kalijarvi, Chuzi, Newman, and Fitch. He, before being at that firm, had 10 years of experience as a solo practitioner and was a DC Refers panel lawyer. He's also a member of MUILA, so we thought he would be a great fit for today's conversation. He's an adjunct law professor at GW Law, and before being a solo practitioner, he ran a law school externship program in DC. He's a man of many, many talents, and I will put the link to his full bio in the group chat, but don't want to spend too much of our time there so that we can get to our conversation. But Steve, I will let you take it away from there. Thank you so much for being with us.
Oh, thank you so much, Nancy. And for all of you who don't know, Nancy Lopez has been the mainstay of DC Refers since its inception and is an indispensable force for good in our legal community. I'm so grateful to you for arranging this program, which is of such intense interest to all of us practitioners in this area. And I look forward to learning from our special guest, whom I will now try to introduce. Eunice Ikene. Have I pronounced that right?
Eunice.
Eunice Ikene or Ikene?
Yes. Yes.
All right. Eunice has been Deputy Chief of Staff to EEOC Chair Charlotte Burrows since this past May. For 2 years before that, she was an EEOC attorney advisor. Before that, she spent 8 years as a labor policy counsel and policy advisor, even before law school, to Democrats on the U.S. House Committee on Education and the Workforce. She worked on wage and hour and on employment discrimination litigation. Some popular names of statutes you've heard of: the Raise the Wage Act, the Pregnant Workers Fairness Act, the Paycheck Fairness Act. She was a field organizer for the Obama re-election campaign in Florida in 2012. She's a 2011 grad of Notre Dame and a 2021 grad of the AU Law School here in Washington. Both before and since she took on her current role in Chair Burrows' office, Eunice has been working on AI issues in employment discrimination law, including, I would say, as a frequent speaker on the subject at events from, gosh, it's a wide variety, from the EEOC Training Institute around the country. She spoke at the Indiana Civil Rights Commission, the Women Tech Leaders event here in Washington, and many, many others. She is an important part of the EEOC's AI and Algorithmic Fairness Initiative. It seems to me that even having such a thing speaks volumes of good about the EEOC trying to really focus on what's coming. Anyway, it's an agency-wide initiative to ensure that the use of AI and other software used in hiring and other employment decisions complies with the federal civil rights laws that the EEOC, and I take it many of us, try to enforce. And with that, I'd love it if Eunice would take it away and tell us a little something about the program, about the initiative, your experience with it. And then I hope you will, jump into what we really should be looking out for, what the wrongs are, and what we need to try to focus on under the existing statutory schemes we've got.
Yeah, definitely. Thank you. Thank you for that kind introduction. So, Steve said, I'm Eunice Ikene. I'm Deputy Chief of Staff in the Office of the Chair at the Equal Employment Opportunity Commission. As you all know, EEOC was created in direct response to the historic March on Washington, and then in the 1960s, the March on Washington for Jobs and Freedom. And since then, our mission has been to prevent and remedy discrimination in our nation's workplaces. And our statutes have been, a mainstay throughout various technological advances in the U.S. economy. So, as you guys might know, algorithms, AI, and other automated systems are becoming increasingly embedded in all aspects of our lives, and that includes employment. I think that with the rise of ChatGPT and GPT-4, last fall, it's really become at the part, it's become a thing in everybody's minds, and so a lot of the recent public conversation has been focused on the potential for AI and generative AI to transform how we live and work. But we believe very firmly here at the EEOC that there needs to be an increased focus on the potential impact these tools have on civil rights. And that's why I'm here with you all today. And so in the employment context, AI and automated systems are already a part of our workplaces. By some estimates, as many as 83% of employers and as much as an estimated 99% of all Fortune 500 companies are currently using some form of automated tools to screen or rank candidates in the hiring process. And we know, that employers are making other employment decisions, such as who to recruit, assign various tasks, promote, or even terminate. They're using some sort of algorithmic tool to help make and inform those decisions. And so the civil rights, that civil rights harms can come from these tools is not a hypothetical or a future problem. These are problems that are here and now. And there's one example that has been it's been reported in the media for several years now. that kind of exemplifies the issues. You know, there was a large tech company developed an algorithm to try and sift through resumes to identify potential candidates who might perform on the same manner as their existing high performers. And what that algorithm found was that it somehow identified those that played lacrosse and those who were named Jared to be characteristics of high performing individuals. They eventually scrapped that tool, so they didn't actually deploy it. But that I think is a decent example of kind of some of the harms that do exist. And so at the EEOC, we believe that this is a new civil rights frontier. And that's why the chair launched the AI and Algorithmic Fairness Initiative in 2021 to help us think broadly about how to ensure that rapidly developing AI and other automated systems are used in ways that reflect our values as a society, particularly the values of fairness, equality, and human dignity. And so our goals through this initiative is to provide guidance and assistance to job applicants, employees, employers, and tech vendors and tech creators themselves to ensure that these technologies are used in ways that comply with our federal equal employment opportunity laws. At the EEOC, we don't endorse any particular technologies or products. So, you know, if you see that, you know, that's probably a red flag. But we do believe firmly that when AI, other automated technologies are used in employment, that they need to comply with the laws that we enforce. As a part of the initiative, the agency has issued 2 technical assistance documents, one focused on the Americans with Disabilities Act, another focused on one aspect of disparate impact analysis under Title VII of the Civil Rights Act. And then earlier this year, back in January, we held a commission meeting to hear from a wide variety of experts and stakeholders, including researchers, civil rights advocates, legal scholars, about the implications of these technologies. And this past summer, I think it was, the chair joined the chair of the FTC, the director of the CFPB, and the Assistant Attorney General for Civil Rights at the Department of Justice to issue a statement saying that, you know, our statutes, the laws that we enforce still apply even when AI is utilized or may be implicated, and that we are, you know, paying attention to these issues. So I can pause there and see if Steve, if you have a specific question, or I can keep going. Let me know.
It's a wonderful idea. In fact, I was just about to post the link that somebody else has just done it. Brandy, thank you so much. I wanted to let everybody know that we really want your questions. I think we can learn from each other. I know I'm gonna learn a ton on this wonderful hour during this special time we got together. If you have a question, put it in the chat. And between Nancy and myself, we will try to read them all out. But we have a great advantage, and that is that anybody can be heard just by unmuting yourself and speaking up during a time of, we'll try to make room for these questions. So Eunice has just invited, I suppose, general questions on the topic. If there's anybody who has one right now, great. Otherwise, we'll move on, and then we'll make sure we'll have 15 or even more than that minutes at the end for questions, either oral or placed in the chat.
I'm happy to, and I can't see the chat right now.
Oh,
but
well, Adrian de Vartanian has something. Can you comment on how you see the recently announced executive order on AI with respect to EEOC? You may be talking about the Biden executive order.
Yeah.
Who else could?
Yes, the President Biden recently signed an executive order on artificial intelligence. We were very excited to see that. The executive order covers a number of different things, like a lot, like it's a pretty long and lengthy document, but there is a specific call to engage on civil rights. And so there are a couple areas where we are implicated. One, there's a specific call to the Secretary of Labor and the Office of Federal Contract Compliance Programs to think about AI and civil rights in the private sector and with federal contractors specifically. And then there's also a call from a directive from the Department of Justice to work with civil rights agencies across the federal government to think about the implications of the use of AI on civil rights. And so we believe that the initiative that we've started is something that fits right in line with the goals of that executive order. We, as I mentioned, we have been already working with our sister enforcement agencies on AI to both put out information that's helpful, but to also on our enforcement end to information share where we can. And so it's something that we're very excited about and really enthused about this whole of government approach and ensuring that civil rights is a key aspect as we're talking about AI. So I can just really quickly, a couple of the resources that we have issued already that might be helpful to you all on our website are a couple of technical assistance documents. The first one deals with the Americans with Disabilities Act. And so early on in the initiative, EEOC issued this document because the law treats persons with disabilities a little bit differently. And we were finding that in the discourse, they were kind of being left out of the conversations. And so when we're thinking about the ADA, it's important to remember that first, disability under the law is broadly defined and could include conditions that aren't commonly referred to as disabilities. And then second, disabilities can be diverse. So even those with the same underlying condition may not experience disability in the same way. So it's not necessarily a group level analysis. And so what we identified in this TA is that there are three main ways that the ADA interacts with the employer's use of an AI or other automated system for employment purposes. So first, the employer could fail to provide a reasonable accommodation to a person with disability. So for example, a person who is blind who uses a screen reader, if they're applying for a job, but the application software doesn't work with the screen reader, that individual might need a reasonable accommodation of a different way to apply. The second way is that employers using AI could exclude someone with a disability from employment or an employment opportunity based on an algorithmic assessment that unfairly screens out an individual with disability. So screen out is unlawful if the individual who is screened out is able to perform the essential functions of the job safely and competently with reasonable accommodation if one is required. And there have been some press reportings around job applicants taking online assessments with major companies, asking questions. These assessments will ask things like, over the course of the day, I can experience many mood changes or things like that could lead to workers with disabilities like depression being screened out. And then the last kind of big way that AI and the ADA interact is that the employer could use AI that violates the ADA's restrictions on disability-related inquiries and medical examinations by posing disability-related inquiries or seeking information that qualifies as a medical examination before giving the candidate a conditional offer of employment. So this type of violation could occur even if the individual does not have a disability. And so, you know, that's a really key aspect. So it could be that if a question that qualifies as a medical examination, it could be seeking information about an individual's physical or mental impairments or health. So in each of these kind of bucket issue areas, it doesn't matter if other people with disabilities were not affected by the AI or algorithmic or automated assessment selection procedure. If even just one person was not accommodated or screened out because of their disability, then the employer could potentially be liable. So that's kind of like the ADA overview. And you can find, we've got a couple of resources I think my colleague Brandy put in the chat. Got everything on our website, eeoc.gov/AI.
All right, couple more questions. Please keep them coming, folks. One person asks, since these processes, potentially unlawful screen outs and other AI-rooted discriminatory processes happen behind closed doors at employers, how are we going to enforce this practically? And then just as a follow-on, has the EEOC started doing that yet? Has the EEOC taken enforcement action in where AI has been used in the agency's view unlawfully?
Yeah, so I can't speak to like anything that's ongoing, but one of the examples, we've definitely been looking at this in our enforcement. One of the cases that our general counsel's team resolved, that's on our website, was a case against a group called iTutor group. And what they were doing, it's not specifically, it was not a disability, it was actually age focused case. But that entity was utilizing an automated filter to screen out people of a certain age from considering them for potential job. And the thing that you mentioned was, how do we even know that whether or not AI is being implicated? And that is a very, very big issue. And one of the things that we have recommended as a potential best practice for employers is to notify upfront their workforces or job applicants that AI is being utilized in the application. And then thanks for putting the iTutor in there. And so what we are trying to do is provide best practices to employers, but then also provide best practices to job seekers and employees about so that they know their rights, and also know specifically in the if AI is an issue, what they could be asking for, reminding them to ask for a reasonable accommodation, if that applies to them. And so we have a couple of resources on our website that we believe can help both workers and employers avoid, if AI or another automated system is being used, kind of avoid tripping up being or violating the law.
Yeah, exactly. I'm looking at the announcement of the suit against iTutor Group that the EEOC put out. This goes back a year and a half, May of 2022. Seems like the most important single phrase in here is a quote attributed to Chair Burrows that says, age discrimination, but could be any discrimination, is unjust and unlawful. Even when technology automates the discrimination, the employer is still responsible. So let's ask the next question. Where does the EEOC believe the line may fall between employer liability and third-party liability for discrimination like this if an employer simply gives over an entire HR function to some third party?
So unfortunately, I can't really answer that. We haven't really taken a position officially as a commission, and so I can't speak to that. But I do think that, what I can say is that, our existing guidance and interpretation on who is an employment agency and
in other words, it's a new problem in joint employer theory.
Is it? I'm sorry, is
One
that a
way to
question?
look at it is it's a new problem in joint employer theory. We often have back office, payroll and hiring screening functions performed by a third party, or unemployment agency or temp agency held to be joint employer with the place the worker goes to be to work, right, suffered or permitted to work in the sense of the Fair Labor Standards Act. So it's fascinating to us, and I'm just wondering what you think, what other people think who are on the call.
Yeah, I mean, I would be interested to hear what other people's take. I know that we have a slightly, our statutes are, a little bit different from the FLSA's suffer or permit to work standard there. But, I think that we are, what the chair said in the statement that she signed with the other federal agencies, that our laws as we enforce them and apply them now still apply even when AI is an aspect and or is a part of that, or some other automated system. In the case of iTutor, it wasn't, you could argue whether or not that was technically AI, but AI is a very broad and overreaching term, so lots of things qualify under that.
Yes, of course. Somebody asks, do you have information? Does the agency have any information about the entities responsible for developing these pieces of software that are, so rife with the potential for abuse? Are there just a few folks who are responsible for developing this stuff? Do you know some of the makers? And is there any way to, have contact with them?
There are, I think what I could share is I would point you to another resource. I think one of we had a listening session, the chair co-hosted a listening session last fall with the Department of Labor's Office of Federal Contract Compliance Programs, kind of highlighting some of the issues and focusing on hiring specifically. One of the panelists there, Wilneda Negron, has done some work with coworker.org, where they have cataloged a number of different types of technology vendors that are out there that are focused on the employment space. And so that's something that either I can follow up via email, and thanks, Brandy. You can see a little bit more of that conversation. I think, I don't have, I think because we don't endorse or condemn, I guess, any specific tech vendor creator, that I would want to avoid, identifying some, but I think that resource, you can take a look at the session that we had. It's links in the chat, but then also you can take a look at that resource from coworker.org.
Good. One of our participants notes that there might be nothing more complicated as to the liability of these third parties than under the law of agency, the common law of agency, which of course is, often plays in both to joint employer and to single employer discrimination litigation. Who else has got a question? You know what? I'll ask you a few. Right now, I'm looking at the joint statement by the four agencies you mentioned: CFPB, EEOC, the Justice Department Civil Rights Division, and the Federal Trade Commission. Here's some food for thought in this excellent but very, shall we say, cryptic, very brief statement of the concern. Many automated systems rely on vast amounts of data to find patterns or correlations, and then apply those patterns to new data to perform tasks or make recommendations and predictions. And while these tools can be useful, they also have the potential to produce outcomes that result in unlawful discrimination. Well, those are some qualifiers. Potential discrimination in automated systems can come from different sources, including problems with inputs, data and data sets, unrepresentative or imbalanced data sets that incorporate historical bias, other types of errors, correlate data with protected classes. All of those things can lead to discriminatory outcomes. Another point the joint statement makes is that the AI models that are out there are often opaque and inaccessible. We can think of them as sort of black boxes, internal workings of which are not clear to most of us. In some cases, even the developers of the tools don't know all the things the tools can do, but that lack of transparency often makes it all the more difficult for developers, businesses, and individuals to know whether an automated system is fair. That's very thought-provoking. And then the third bullet here on the joint statement: design and use. It says developers do not always understand or account for the context in which their software will be used. Developers can design a system on the basis of flawed assumptions about the users, the audience, the relevant context, or the underlying practices or procedures, particularly in employment, that their software may replace. So, distinguished speaker, whom we're so happy to have, does that give you any thoughts of things you would like to address here? And the same goes for everybody else in our audience.
Yeah, I can just really quickly on, Title VII of the Civil Rights Act and disparate impact, we put out a technical assistance document earlier this year. And I think one of the things that we have seen is that the use, so I guess let me back up, under Title VII, which protects against sex, race, religion, there's when an employment screen has a disparate impact, meaning it eliminates people from a particular group to a degree that's disproportionate. It's legal only if it's job related and consistent with business necessity, and if there's no less discriminatory alternative way to meet the business goal. So the EEOC's uniform guidelines on employee selection and procedures, you'll hear that brought up a lot in the context of AI and employment. So these are guidelines that have been in existence since 1978, and they are guidelines for employers to that apply to anything that might be considered an employment selection procedure or test. So I think what we have observed is there's a lot of there's kind of a few different ways people get it, talk about the guidelines. One is like, okay, like the guidelines are super old, so they need to be updated. Or two, like there is this test in the guidelines, or there's this rule of thumb in the guidelines. And so, if we technology vendor optimize to that test, then our AI or other automated tool is not going to violate Title VII. So first, I would say the uniform guidelines apply to AI-based selection procedures, and they're a critical tool for employers and tech creators as they create and implement these technologies. So that is like step one. It definitely applies, doesn't matter how old they are, it still applies in this context. The other thing that I want to mention is that some vendors claim that their product is bias-free simply because they run tests and tweak their algorithm or AI to ensure that the selection doesn't violate what we call colloquially the 4/5 rule of thumb. So in other words, they check to ensure that the selection rate for any particular race, sex, or ethnic group is not less than 80% of the rate for any other group. What seems to be getting lost is that this 4/5 rule of thumb, which is mentioned in the guidelines, isn't the only standard. It's simply a guideline that us and the other agencies that have adopted the UGAS or the Uniform Guidelines, we adopted that for ourselves as a rule of thumb in our investigations. So in enforcement, the EEOC and the courts, if the matter is litigated, they look at other measures like statistical significance when assessing whether a particular selection procedure is discriminatory. So that's just kind of like a general thing to push back on, that we've provided information to employers and tech creators specifically on this issue, but it is something that has come up a lot in the AI conversations. And so just thought I would flag that for you all.
There are a couple of other questions in here. One, has the EEOC run into, or do people on the call believe there are, conflicts between the proprietary nature of the AI software and the public need for transparency to be able to review the software and its inputs for compliance with the law? We see the same problem in voting machines, where proprietary software is hidden away, and there are efforts in the university sector, in the nonprofit sector, to try to develop open source software for these kinds of things. But I wonder if you've run into that. And then the other one is a litigation question that I'll get to in a moment. What do you think about the possible conflict with intellectual property issues?
Yeah, I mean, I think that is that's an interesting question. I think that when we are doing an investigation, we have sets of tools, right, to utilize. And I don't think that the AI context or the use of an AI tool is, I don't think this idea is a novel, like proprietary information is a novel thing just because AI is being used. I think it's something we've, had to deal with for, in other contexts as well. And so I think that, that isn't necessarily going to deter us. And it's something that I think with respect to the black box kind of issue, I guess I'll just categorize it as that there's I think we're starting to see I guess let me back up. One of our best practices that we suggest in both the ADA document and in the Title VII document that you've linked to in the chat is this idea of transparency. Employers should, as a best practice, try and be transparent about the AI and the tools that they're using so that workers, job applicants know what's going on and they can be able to call upon their rights when they feel like their rights have been violated. So that is, I would say, like, that is something that is talked about a lot. It is something that we, have put out there as a best practice. And then on the other side, I would say, I think we're starting to see, or I think New York City's law that we don't have a position on, but we have been just kind of watching what's going on, their auditing law. I think we'll start to see what happens when various entities are required to, audit their tools and put that information out publicly. So I think there are some lessons, to be learned. We're hoping that we'll be able to learn some lessons from what New York City has, what they're enforcing currently.
I think I'm looking for more questions in here. It's 11 after 5. we all have busy lives, but this is, I'd love for this conversation to go on for hours. What can we do to increase the pool of knowledge about how these algorithms are being used? And let me specify particularly, because we're litigators, so we're thinking about how can we get at this? And is there a not to say pre-enforcement exactly, but is there a cause of action for discriminatory algorithms without proof that they've actually been used against people, which of course is even harder to obtain? I wonder if you have any thoughts about how litigators ought to go about doing this.
I would say start by looking at our documents on our website, selfish, shameless plug. Take a listen to the hearing. I think the recording of the hearing is on our website, and it kind of lays out at a high level and at a pretty deep level what the issues are. And then I think that as one of the things that might be somewhere, something to consider is that, when someone applies to a job and gets an automatic bounce back immediately, or gets some sort of rejection at like 1 a.m, or, there's a chat bot that pops up and they're, when they're on a job board, or if they have some sort of virtual interview that utilizes a very specific, software, those are things that, people should be, looking at and, thinking critically about, because I think that we believe that we support innovation, and that innovation should not come at the cost of people's civil rights. And so I think our tact is to, really get out there and try and educate. And also, I think not take for granted or assume certain things because they happen all the time, or, we're just used to it as a society. I don't know if that makes sense, but maybe that has sparked some interest and some curiosity. And
I'm about to post the New York City anti-bias, algorithm bias bill. It's called Local Law 144. Do you know of any other initiatives of this sort beyond the ones in New York City and DC? And by the way, the one in DC is sort of stalled. Robert White says he's going to commit himself to reintroducing it in some form, but that has not yet happened.
I think that California is considering some privacy laws. I think I'm starting to get a little bit out of my depth. I think that there's a lot of interest even here in DC and Congress. So that's something that we're taking a look at, or we're monitoring, watching. But we are focused on implementation of the executive order and working with our sister enforcement agencies. And look forward to interacting with you all. And if you guys in the course of your work have come across things, that's definitely something we are interested in hearing about, because we're interested in hearing from all different types of stakeholders, whether it's the employer community, tech creators, vendors, definitely civil rights and workers as well. So yeah, that's kind of what I would put out to you guys.
Yeah. Well, the technical assistance document is actually pretty detailed and powerful, especially given that it's so early in all our thinking about this. I commend it to all of you. If there are no further questions, I wonder if you have any final remarks you'd like to offer to us, Eunice, because we'd love to pick your brain.
No, I'm happy to continue the conversation. This is definitely a priority issue area for the chair, for the commission. It was a part of our AI appears in our strategic enforcement plan that's going to govern and direct kind of our work for the next 5 years. I think, don't quote me on that, look on our website. And so it is something we're taking very seriously as something that we need to address, especially as we're dealing and trying to combat systemic discrimination in all of its forms.
Bravo. If there are any other questions, let us know. And as you can see, Nancy is thanking us for thanking you, Eunice, for your time today. Let's ask one last question. If we have ideas, where should we bring them? If the EEOC would like to hear them, what's a good way to get them to you in a form in which you can use them?
Oh, you can email me. Hold on, I can, either you guys can circulate. Let's see, I can circulate. Oh, there you go. Thank you, Brandy. Thank you, Brandy, you can shoot me an email.
Wonderful. You just put that in the chat?
Yes, both of our emails, myself
There you
and my
go.
colleague
Terrific.
Brandy.
So I second that, folks, as a way of furthering the conversation. I'm so grateful to you, Eunice. We all are. We'll stay on for another minute. If people want to paste, block and paste the chat, now's the time to do that. It's got some links in there that I think you might find very useful. I'm not sure how that gets preserved in the recording. So for this to be as useful as possible to all of us, let's create an opportunity to do that. And let me just say thank you so much on behalf of our sponsoring organizations, MOELA, the Labor and Employment Law section of the DC Bar, and above all, DC Refers. I'll put in a shameless plug for DC Refers at the end here and just say it is indispensable. We're without very much in the way of legal help for people who think they have good cases, who aren't sure what to do with them, who make too much money and income for the guidelines for legal aid, or must otherwise be turned away from legal services. We all do an enormous, inestimable service to those folks and to the law in general by joining networks like this one and giving as generously as we can of our time and resources. Once again, I'm so grateful to all of you for attending. And at that, we'll say goodbye. Thank you again, Eunice.
Thank you. Thank you for having me.
So long, everybody.